Well, the counsel of the private respondent, since he's having some personal difficulties, so he's not
Your
there
Lordship,
today.
my senior has a medical emergency.
Okay. Heard Mr.
I'm entering common.
N.K. Lukham, learned counsel for the petitioner, also heard Miss
And solo for
N.
respondent.
N. Solo for respondent number 3, who submits that her senior, Mr. A. Zimomi,
Imti Longjung.
Mr. Imti Longcham, is having some personal difficulty, and on that ground prays for an adjournment. Prayer is allowed. Let this matter be listed after 2 weeks. After 3 weeks.
Your Lordship, I would also like to mention item number 15.
Heard Miss Hens, who is, you are for the petition.
Follow, yes, probably.
Heard Miss Mr. N.K. Louis Kham.
In this case, I am for the April. If it is cases adjourned, it may be fixed on 8th of April.
8th of April. Heard Mr. A.C. Sharma, learned senior counsel, assisted by Mr. N.K. Louis Kham, learned counsel for the appellant. Also heard Miss N. Solo,
Respondent 1.
learned counsel for respondent number 1, who's prays for an adjournment on the ground that her senior, who is the conducting counsel for respondent, Mr. Imti Longchen, who is having some personal difficulty. Considering the ground, the prayer is allowed. Let this matter be listed again on 8th of
April.
8th of April.
Much
I
more.
am.
May I please, my lord? Lordship, I beg to mention item number 19 and 20.
Yes,
Lordship, if this matter can be listed on Thursday.
No objection.
heard Mr. Enangami, learned senior government counsel, praying for listing this, praying for an adjournment today, and also praying for listing the matter on
Thursday would be not the
14th of
14th.
March. Mr. Senti Younger, learned counsel for the petitioner, does not opposes the prayer, hence the prayer is allowed. Let this matter be listed again on 14th of March.
I'm deeply obliged for
Deeply
it.
obliged, Lordship. Lordship, I have a similar prayer for hearing item 18. I have taken the counsel of the counsel of the.
Heard Mr. Senti Younger, learned counsel for the petitioner, who is praying for an adjournment with the consent of learned counsel for the state respondent. Considering the submission, the prayer is allowed. Let this matter be listed after
14, Lordship.
on 14th.
Yes, Lordship.
Let this matter be listed again on 14th of March.
Deeply obliged.
Obliged, Lordship. Please, Lordship. I beg to mention item number 1, 2, and 3. These are analogous matter. Only this matter may be listed after 2 weeks.
Why are you praying for adjournment?
Lordship, we are filing an IAS before the civil court, Lordship. So
Okay.
if that is allowed, then nothing remains in this petition, but we are yet to file.
Okay. Heard Mr.
I am your Lordship.
I. Imchen, learned counsel for the revisionist in all 3, item number 1, 2, 3, who prays for an adjournment on the ground that the petitioner is proposing to move the civil court by filing an IA, and in case the said IA is allowed, this revision petition before this court may become infructuous. Also heard Miss
And Rochelle.
N.
Rochelle.
Loshino
Rochelle, ROCHI.
Rochelle, learned counsel for
Respondent numbers 1 and 2.
respondent number 1 and 2, who does not oppose the prayer, hence the prayer is allowed. Let this matter be listed after 3 weeks.
Much
Much
obliged.
obliged.
May I please, Your Lordship? Your Lordship, I beg to mention hearing item number 16. Your Lordship, I'm sitting on behalf of my seniors. I pray that this hearing matter will be fixed on 26.
What is your name?
CPO, Your Lordship.
C
CPO, Your Lordship.
E O
PHOM.
P H C form. You are for the appellant or?
Yeah, for petitioner, Your Lordship.
Yes, heard Mr. C form. Learned counsel for the, you have informed the counsel for respondents
The counsel has been taken from the respondent.
who is praying for an adjournment with consent from learned counsel for the respondent. Considering the submission, the prayer is allowed. Let this matter be listed after.
Let this hearing be fixed, Your Lordship, on 26/3.
On 26th of March 2024.
Your Lordship, send prayer will be reflect on item number 4. Let this matter come up tomorrow, Your Lordship.
Day after tomorrow.
Tomorrow, Your Lordship, item number 4.
I'm for respondent number 1.
Yes. Heard Miss C form learned counsel for the petitioner who prays for listing this matter tomorrow, that is 13th, 12th of March. Mr. M. Vero, learned counsel for the respondent, does not opposes the prayer, hence the prayer is allowed. Also heard Mr. KV, you are also there. KV Angami, learned counsel, learned public prosecutor, who also concedes to the prayer, hence the prayer is allowed. Let this matter be listed accordingly.
Please, Your Lordship, I'd like to mention item number 22, Your Lordship. For the hearing item. I pray that this matter may come after 3 weeks, Your Lordship, since my senior has some personal difficulties. I have
Your senior is
some personal difficulties today.
heard 22, heard Mr. M. Vero. Mr. Foseko Forte is having,
Yes, Lordship.
who is for the petitioner,
El Iralu, Lordship. I've taken the consent from
who prays for an adjournment due to personal difficulty of his senior, Mr. Foseko Forte. It is also submitted that the learned counsel has informed the learned counsel for the petitioner regarding his prayer for adjournment. So also Mr. KV Angami, learned government counsel, government advocate Nagaland, who does not opposes the prayer. Hence the prayer is allowed. Let this matter be listed after
3 weeks, Lordship.
3 weeks.
Obliged, Your Lordship.
Lordship, notice upon respondent number 2 is still awaited. So kindly allow us to serve custody service upon respondent number 2 within a week.
What is your name?
Ayala Inchin.
Heard Miss
Ayala Inchin.
Ayla Imchen, learned counsel for the appellant. Also heard Mr. M. Vero appearing for the respondent, respondent number 1. Learned counsel for the appellant submits that the notices on respondent number 2 is still, service of notice on respondent number 2 is still awaited. Hence, she prays for allowing the appellant to take steps for issuance of service of notice on respondent number 2 through dusty mode. The prayer is allowed. The petitioner, the appellant shall take steps for issuance of notice through dusty mode on respondent number 2 within 1 week from date of this order, returnable after 4 weeks. List accordingly.
Lordship, there is an interim.
The interim order shall continue till next date.
Obliged.
Lordship, I'd like to mention item number 9. The petitioner for the the counsel for the writ petition is Mr. Gauhati. His name is not reflected, so he had overlooked the process. So can we pass over the matter to tomorrow?
Heard Miss
Ubang Nanla Longchar.
Obang,
Ubang Nanla Longchar.
Obang Nanla Longchar, learned counsel for the petitioner, learned counsel who submits that the due to non-publishing of the name of the learned counsel for the petitioner in the cause list, namely Ms. Supang,
Mr. Supawati.
Mr. Supangwati Wali, he has overlooked the cause list and therefore prays for fixing this case tomorrow, that is on 12th of March 2024. Stop. Mr. KV Angami, learned government advocate, does not opposes the prayer, hence the prayer is allowed. The registry shall reflect the name of the petitioner in the cause list henceforth. List accordingly.
Yes, sir.
For admission, item number 5.
Lordship, on the earlier of the SSC's honorable court, order dated 29/9/2022 was placed to allow an interim anticipatory bail to the applicant here. When she has tasked off to do all the conditions imposed by his honorable court.
When you were granted interim by dated 29,
29 September 2023. Now I am informed that the charge sheet is also already been filed and custodial interrogation is not required. And also this is more or less a family dispute. In fact, this should not even have been,
you have appeared before the IO.
yes. Bail form has also been executed,
Okay,
which I have placed on record.
you have anything to say?
I have received the instruction, Lordship. As far as instruction is concerned, Lordship, now the charges have already been. I would like to place that on.
Now, what is your submission?
Lordship, since now the investigation is over, Lordship.
The interim anticipatory bail may be made absolute. Heard Mr. Senti Younger, learned counsel for the petitioner, also heard Mr. V. Zimomi, learned public prosecutor for the state of Nagaland. Stop. Learned counsel for the petitioner has submitted that the petitioner had approached this court by filing an application under section 438 of the Code of Criminal Procedure, 1973, apprehending his arrest, her arrest in connection with Kohima South PS case number 39/2023 under section 468/423 of the Indian Penal Code. Stop. It is also submitted that by order dated 29/9/2023, the petitioner was allowed to go on interim anticipatory bail by this court with certain conditions. Stop. It is further submitted that in pursuant to the directions of this court, the petitioner has appeared before the investigating officer and has cooperated with the investigation. Stop. Learned counsel, learned public prosecutor has submitted that whether case diary was called for.
Lordship, on the last occasion, since I don't have the instruction with me, Lordship, I have fixed a week's time to get a system instruction.
Learned public prosecutor has submitted that in the meanwhile, the investigation has been completed and the investigating officer has already laid charge sheet on 7/11/2023 before the Court of Learned Chief Judicial Magistrate Kohima after the completion of the investigation, stop. As the investigation has been completed and as it appears from record that the petitioner has complied with the directions of this court and has cooperated in the investigation, therefore, the interim anticipatory bail granted to the petitioner by order dated 29/9/2023 is hereby made absolute with conditions number Roman 2 and Roman 3 attached to the said order remaining intact. With this observation, this anticipatory bail application is hereby disposed of.
For admission, item number 6.
No one is for petitioner. None appears for petitioner on call. Miss A. Aimi, Learned Government Advocate. Appears for respondent number
1 and 2.
1 and 2. You have filed the rejoinder?
Yes, sir.
Okay. Let this case be listed after 2 weeks. All right.
What's your pleasure?
For admission, item number 7.
Yes.
I know there's delay of 47 days. However,
47 days in filing the
yeah,
appeal or revision.
yeah. But why not in para 4? In para 4, my IA application.
Can unmute.
Yes, para 4.
Yeah. I read out, that is the delay of 47 days. And that under the Limitation Act, Schedule 1, Rule 131, the limitation period is 90 days. And that the limitation is well within the schedule.
You're reading para 4 of?
4 of IA 136, which was allowed.
136. There is no I-136 is disposed of. Albert.
Yes, report.
We are taking up IA number 111.
IA 139, Lordship. 136. 139.
Where are you reading? IA number?
Yeah,
Because in
111.
111, para,
My lord, I'm going to refer the para, but my lord, I would like to take this honorable court to understand. The Limitation Act. Schedule. First schedule rule 131.
yes,
I read out the rule.
Albert, limitation act. Yes, please read.
Yeah. To any court for the exercise of its power. Shall. Under the code of civil procedure. Or the code of criminal procedure. The limitation period is 90 days.
Yes,
So 47 days come within that 90 days.
No, you have stated that delay is of 47 days.
47
This
days.
47 days after 90 days.
47 days is within that 90 days. That's what I mean.
Then
So-
why you have mentioned it to be a delay? If it is within 90 days, then there is no delay.
I don't, it was over. And for that I felt delayed. But however, it came to my knowledge that it was within that.
So this 47 days is computed from which date? Why have you mentioned it to be 47 days? From the date of impugned order?
Computed from. The first 7, you 5, 9, in 3.
Impugned order is dated. What is the date of impugned order?
The first 7, 2022.
And you have filed this revision.
Yes.
When have you filed this revision petition?
14 September 2022.
Six, 9/2023. It has been filed on 6th of September 2023. It is more than 1 year delay. When have you filed the revision petition? Yes, date of filing, date of receipt is 8/9. 8/9/2023. Date of filing is mentioned as 6/9/2023. It was received on some, so there, the filing is after more than 1 year. Then how it can be within the period of limitation? And how there is only 47 days delay? I am not understanding. Mr. Zhao,
Yeah.
you prepare yourself and we'll take it up tomorrow. I think you are not prepared. So we'll take it up tomorrow,
I will get it here on Thursday. Thursday.
Thursday. Okay, we'll take it up, Mr. You have received the notice of against the limit, the IA, only IA. Heard Mr. Elivel Zhao, learned counsel for the applicant, also heard Mr. Kekrinule, learned counsel for the opposite party. On request of learned counsel for the applicant, let this matter be listed again on 14th of March 2024.
Right.
for admission, item number 8.
View of the compromise that has been entered between the parties, the informant and the accused person, I am filing this criminal petition, for quashing of an FIR. I will take your lordship to the first the compromise thereafter. I will take your lordship to page 35, Actually, there was one financially consultancy agreement has been entered between the informant and the accused person, And in view thereof, some amount has been paid as a charge for obtaining loan by the second party. In the favor of second party by the first party.
Whether this, who is appearing for the
Both the accused and the informant, both they have come together.
joint petition?
Joint petition.
Okay.
So I will take your lordship to page 35, there is the MOU.
Yes.
I will just take the first condition, madam. There are three conditions, madam. That the first party approves the second party for procuring financial assistance of ₹50 crore from the financial institution. So, my lord, the first party is the informant form, my lord. And second party is, my lord, first party is the, my lord, accused form, my lord. This is the consultancy form, my lord. And the person is the, my lord, promoter of the form, my lord. There was an agreement of the first party for procuring financial assistance of 50 crore from the financial institutions for bank in their business. The second party has agreed to provide their skill-based services for procuring the financial assistance of the firm. The second party is working in the financial consultant. That the first party had paid total sum of 1.5 crore to the second party through bank transfer for availing service of the second party. Thirdly, due to unavoidable reason, the deal could not be completed and dispute has arisen between both the parties. The affair has been filed before the West Dimapur police station. The same is pending before the concerned police station, and FIR number so has been registered on the said complaint under section 417, 420 of the IPC against the second party, and the same is still pending for investigation.
417, 420, whether these are compoundable offense?
Is compoundable with the order of the
So you could have compounded the offense by approaching the court.
In this case, since the matter has been settled, and I have the judgment of this on the apex court, in a case when the matter has been settled within the parties, and they can approach this on court, and your lordship on the court has the power to work on it. It is done by this court. I'll just let down this always judgment before lordship.
Okay.
So, clause 6, with the intervention of the friends and common persons, both the parties have mutually agreed to settle their disputes. Civil, criminal, past, present, and future, and it will sum of 1.5 crore. And except the same amount, the first party will not claim anything on the ground, which include interest, litigation, expense, or anything. This is the condition. Number 9, the first party is undertaking to appear before the court, including the High Court, for quashing and disposal of an aforesaid affair without any delay, and when the same is to be listed for insurance or others. And 11 is the mode of payment. Payment has also been done, madam. And the mode of payment will, which has been settled between the parties are as under. The second party is paying 50 crore on price ransom and 1 crore price. This amount has also been paid, madam. So ultimately, end of the matter has been settled, madam.
Okay.
Now, my lord, I will take your lordship, my lord, to the FIR, my lord, now. That is, my lord, at page 32, my lord.
Yes.
Yeah, it was basically same thing has been depicted in the FIR, my lord. It was basically there's consultancy for consultancy. There's charge of 1.5 crore has been given to the accused person. Ultimately, he could not do it, and in terms of the contract, my lord, he's supposed to return, but he did not return it. So ultimately, my lord, there was misunderstanding, and thereafter this lodging of an FIR.
Okay.
And I will just show you lordship to page 22 is the financial agreement, my lord, that has been entered, my lord. So ultimately, my lord, the matter has now been settled between the parties. Now I will take your lordship to some of the judgments, my lord. In a case, my lord, when the compromise has been entered, what the apex court has laid on the guidelines, my lord, and power of your lordship under 42, my lord. I will just please see your one judgment you office in the court. Very latest judgment, my lord. The first judgment, one of the Gyan Singh judgment, madam, Dr. is arrest, 2012, 10 SSC 303, madam. I will just take your lordship without bothering much, madam, to paragraph 58, madam. Paragraph 58. In Janssen case, my lord, everything has been discussed, my lord, regarding compounding of the non-compounding offense as well as certain other offense, my lord. So I will take your lordship to, paragraph 58, my lord. The first few lines I will read, my lord, where the High Court washes a criminal proceeding having regard to the fact that the dispute between the offender and the victim has been settled for an offense, are not compoundable. It does not. It does so as in its opinion, continuation of criminal proceeding will be an exercise in futility, and justice in the case demands the dispute between the parties is put to an end and peace is restored, securing the end of justice being ultimate guiding factor. Then I will take your lordship to the next page 341, madam. However, madam, there are certain offenses, madam. So that is relevant, madam. However, the first line, madam.
Where are you reading?
Page 341, the first line, madam.
However, yes.
This is relevant, madam. However, certain offenses, madam, which overwhelmingly and predominantly bear civil flavor, having arisen out of civil, mercantile, and commercial, financial, and partnership, or such like of transactions and offense arising out of matrimony, particularly relating to dowry, etc., or the family dispute, where the wrong is basically to the victim and the offender and the victim have settled the dispute between them. This is very important, irrespective of the fact that such offenses have not been made compoundable. The High Court may, within the framework of its inherent power towards the criminal proceeding or criminal complaint or affair, if it is satisfied that on the face of such settlement, there is hardly any likelihood of the offender being convicted, and by not quashing the criminal proceeding, justice shall be casualty and end of justice shall be defeated. The above list is illustrative and not exhaustive. Each case will depend on the facts and circumstances, and no hardened first category can be prescribed. Now I will take your lordship to para 61, madam. The position that emerges from the above discussions can be summarized thus. The power of the High Court in quashing of a criminal proceeding or FIR or complaint in exercise of its inherent jurisdiction is distinct and different from the power given to a criminal court of compounding the offense under 320 of the code. Inherent power is a wide plenitude with no statutory limitations, but it has to be exercised in accord with the guidelines engrafted in such power which to secure the end of justice and to prevent the abuse of the process of any court. In what cases the power to quash the criminal proceeding or complaint may be exercised where offender and the victim have settled their dispute would depend on the fact and circumstances of each case, and no category can be prescribed. However, before exercising such power, the High Court must, having regard to the nature and gravity of crime, heinous and serious offenses of mental depravity or offense of like murder, rape, deputy, etc., cannot be fittingly quashed, even though the victim and the victim's family and the offender have settled the dispute. Such offenses are not private in nature and have serious implications. But in our case, my lord, it is a very private nature, my lord. It is a contract between the parties, payment has been restored. So since it is a private in nature, my lord, it can be easily settled, my lord. Thereafter, I would read, my lord. Similarly, any compromise between the victim, so it is in connection to other parties regarding the heinous crime, offender in relation to the offense under special act like Prevention of Corruption Act, so and so by the public servant while working the capacity cannot provide any basic for such quashing criminal case involving such offense. But now is important. But the criminal cases having overwhelming and predominantly civil flavor stand on a different footing for the purpose of quashing, particularly the offense arising from commercial, financial, mercantile, civil, and partnership, or such like transactions, or the offenses arising out of matrimony related to dowry, etc., or the family dispute where the wrong is basically private or personal in nature. The parties have resolved their entire dispute. In this category of the cases, the High Court may quash the criminal proceeding if it is in his view, because of the compromise between the offender and the victim, the possibility of conviction is remote and plain, and continuation of the criminal cases would put the accused to great oppression and prejudice, and extreme injustice will be caused to him by not quashing the affair, because despite full and complete settlement and compromise with the victim.
In other words, the High Court must consider, my lord, consider whether it would be unfair or contrary to the interest of justice to continue with the criminal proceeding, or continuation of the criminal proceeding would tantamount to abuse of the process of law, despite settlement and compromise between the victim and the wrongdoer, and whether the secure end of justice. It is appropriate that the criminal case is put to an end, and if the answer to the above question is the appointment, the High Court shall be well within the jurisdiction to pause the criminal proceeding.
So this is the case, Mother, which is the view of private nature, Mother. This is a transaction between two parties, Mother. The amount has been settled, and now both parties has come before your lordship, Mother, for question, Mother. So in that view of the matter, Mother, in principle, the guidelines which have been narrated by the Supreme Court Gansing, Mother. So I am humbly praying, Mother, this FIR may be crossed, Mother. I am also referring to another judgment, Mother, of the Supreme Court, Mother, on which, based on this judgment, Mother, and it is, Mother, 2019 5 SSC, Mother. The principle has been laid down, Mother. 2019 5 SSC 688, Mother. In that paragraph, you have 15, Mother. So the things that have been the principle that has been laid down in the Gansing has been reiterated, my lord. That is 15.1, my lord.
Okay.
15.1, that the power conferred under 482 of the code to quash the criminal proceeding for so and so. So this is the principle that has been laid down, my lord. So I will place another judgment of this honorable court, a very recent judgment of this honorable court, my lord, of 1st of February 2024, my lord. In that judgment, I am relying the paragraph I have just mentioned top in the judgment, my lord, 7, 8, 13, 14, 15, and 17, my lord. So I will take your lordship to page paragraph number 7, my lord. Paragraph number 7 here, it refers to Anita Maria case, my lord. It's 2018 3 SSC. It is the case where if the case is in the investigation stage and if the matter is compromised, my lord, then the court is mentioned, my lord. In a case, I quoted there are 7 of the judgment, my lord. In a case like this, where proceeding are still at initial and in the same state, the High Court should have exercised its discretion in quashing the proceeding. Law in this behalf is well stated by Ketana of judgment in this court by so and so, so and so. So in view of the above discussions, we sum up and lay down the following principles by which the High Court will be guided in giving adequate treatment to the settlement between the parties and exercise of power under 42 of the court while accepting the settlement and quashing of the proceeding or refusing to accept the settlement with discretion to continue with the criminal cases. Okay. So power has been discussed, mother, and ultimately, mother, the details has been stated, mother. Power conferred under section 482 of the code is distinguished from the power lies in so and so, so and so. That it is scope to compound the offence under section 320. No doubt, under section 482, the High Court has an inherent power to quash the criminal proceeding, even in those cases which are not compoundable, where the parties have settled the matters between themselves. However, this power is exercised sparingly with portions. When the parties have reached a settlement and on that basis petition for quashing of the criminal is filed, the guiding factor in such cases would be secured. Number 1 is end of justice, and number 2, prevent the abuse of the presence of court. And while exercising the power, the High Court is to form an opinion or either of the aforesaid two objectives. Such power is not to be exercised in those prosecutions. So it tells about the seriousness of the crime. On the other hand, those criminal cases having overwhelming and predominantly civil color, particularly arising out of commercial transactions or arising out of matrimonial relationship or family dispute, should be quashed when the parties have resolved their entire dispute among themselves. This is a case, Malak, where the parties of private nature, Malak. So, Malak. So, and then other paragraph, Malak, ultimately, in this case also, Malak, the affair has been quashed, Malak. So, you may kindly see the paragraph number 15, Malak. It has been held, Malak, from the above judgment of the Honorable Apex Court. It is now fairly settled. Paragraph 15, Malak, that this court under section 482 can quash the criminal proceeding on the ground of compromise arriving at between the parties. The law is also settled that if the dispute is private in nature and does not affect public at large, in that case, even the criminal proceeding for non-compoundable on the basis of compromise can be quashed by this court while exercising power under section 482. In the instance case, the offense in 409, 461 and are non-compoundable offense, but dispute between the parties are purely private and civil nature and which is arising out of money transaction and subsequent misunderstanding between the parties. While the case is under still investigation, the initial stage of parties have settled the dispute. Under this circumstance, even if the investigation of the proceeding is allowed to continue, the case is likely to end in acquittal and therefore the criminal case should not be allowed to proceed to create hurdle in their peaceful living order. In their view of the matter, Madam, the affair was directed to the court, Madam. So may I pray, Madam?
Mr. Angami. Anything to say?
Much. The 15th of February, when this case was moved, I have been directed to obtain the status report of the case. And as per the status of the case received during the course of the investigation, they have received through mail from the council of the legal advisor that they have that a memorandum of understanding. The copy has been received by the police investigation agency, and that what they have stated was that the matter is under investigation. That much was a sufficient price lawyer. So in the view of the matter, I give it to my lords. Not appropriate for the.
At page 40, Madam, already we have informed the IO matter at page 40, Madam, that they have settled the matter and the matter has been compromised along with the copy. At page 40, I have annexed that letter.
Heard Mr. G. Alam, learned counsel for the petitioner. Also heard Mr. K.V. Angami, learned public prosecutor for the state of Nagaland. This application under section 482 of the Code of Criminal Procedure, 1973, has been jointly filed by the petitioners, namely Dr. Alamla Iyer and Shri Vipin Kumar, praying for quashing of the FIR dated, where is the FIR?
My lord, document file, my lord, at page 32, my lord. I have mentioned in my prayer at page 15, my lord, is there, page 15, may be.
Just a minute.
Fair in West PS case.
FIR dated?
Fair dated, my lord, it is, my lord, 14/3/22, my lord. In the top, my lord, page 32, it is there, my lord. In the top, my lord, date.
Is not on FIR dated 14/3/2022, on the basis of which West PS case number 50/2022 under section 417/420 of the Indian Penal Code was registered. The case of the petitioners is that the petitioner number 1 is the proprietor of Messrs. Eden Medical Stores and Messrs. Lemka Pharma, with its office at Kashiram Road near Sub-Jail, Dimapur. And the petitioner number 2 is the proprietor of Shanky Finance, with its office at 1116, 11th floor, D Mall, NSP Pitampura, Delhi 110034. On 14/3/2022, the petitioner number 1 had lodged an FIR before the officer in charge of East Police Station, Dimapur, Nagaland, inter alia, alleging that a financial consultancy agreement was entered into between the petitioner's company, petitioner number 1's company, as well as the company of the petitioner number 2, Messrs. Shanky Finance. And as per the said agreement dated 25/8/2018, the petitioner number two's company had to provide consultancy services for procuring financial assistance of 50 crores from financial institution slash banks slash NBFC slash others to the petitioner number one's company. Huh? Firm, petitioner number one, firms instead of company firm. And it is further stated in the FIR that as per the terms of the agreement, the firm belonging to the petitioner number one, that is Messrs. Eden Medical Center had transferred to the firm of petitioner number two, namely Shanky Finance, an amount of rupees 1 crore 50 lakhs as advance payment for loan insurance charges under the agreement. And it was also stipulated that if the petitioner number two's firm, namely Shanky Finance, does not deliver the loan amount within 15 days, the said advance amount was to be refunded back to the petitioner number one. It is further alleged in the said FIR that the Shanky Finance, the firm belonging to petitioner number two, was not able to fulfill its part of the commitment, and accordingly it was liable to refund back the agreed amount. However, the said amount was not. No. However, against towards the refund of the said amount, the Shanky Finance had issued 4 checks, and all the said checks were dishonored by the bank due to insufficiency of fund. It is thereafter alleged in the FIR that the petitioner number two company has defrauded the petitioner number two firm has defrauded the petitioner number one and have committed the breach of agreement entered into between petitioner number one and two. Stop. On receipt of the said FIR, the West Dimapur PS on receipt of the said FIR, a West Dimapur, a GD entry was made bearing GD entry number 5/2022 in the police station, and thereafter West Dimapur PS case number 50/2022 under section 417/420 of the Indian Penal Code was registered. Stop. Next para. Learned counsel for the petitioner has submitted that thereafter the filing of the FIR by the petitioner number one was due to the misunderstanding which cropped up between the petitioners, and now the dispute between the parties have been amicably resolved between both the petitioners, and to that effect, they have also executed a settlement deed / memorandum of understanding on 22nd day of November 2023. What was the terms?
Terms thereof, enter payment has been made.
And the said, you have annexed
Yes,
this
Malad, I have any, page 35, it's start by. Page 35.
as annexation number.
Election number, Malad, election number, Malad, 6, Malad, 34 videos, Malad. Election number 6.
The petitioners have annexed the said deed of settlement as annexation number 6 to this criminal petition. And it is contended by it is submitted by learned counsel for the petitioner that in pursuant to the said settlement deed, the entire outstanding due has been paid by the petitioner number 2 to the petitioner number 1. Stop. It is further submitted by learned counsel for the petitioners that where the clause is that you will file a joint petition.
Yes, Malad, is there.
Quashing petition.
If, Malad, 9, Malad.
It is further submitted by learned counsel for the petitioners that there was a stipulation in the memorandum of understanding, that is clause 9 of the said memorandum of understanding, whereby it was agreed upon between the said petitioners that after the settlement of the dispute between them, the first party, that is petitioner number 1, shall take necessary steps by approaching appropriate court for quashing of the FIR. Stop. It is contended by learned counsel for the petitioners that in pursuant to the deed of settlement entered into between both the petitioners have approached this court by filing a joint petition for praying for quashing of the said FIR. Stop. It is further submitted by learned counsel for the petitioner that the offense under section 417 of the Indian Penal Code is a compoundable offense, whereas the offense under section 420 of the Indian Penal Code is compoundable with leave of the court. It is also submitted that the dispute which was there, which has already been settled between the parties, was predominantly of civil nature, and as the first informant, that is the petitioner number 1, and the accused, that is the petitioner number 2, have settled all their dispute between them amicably, it would be futile to proceed. It would be futile to allow the criminal proceeding to proceed any further. In support of his submission, learned counsel for the petitioner has cited rulings of following rulings of the apex court as well as of this court. Number 1, Gyan Singh versus State of Punjab and another reported in 2012 10 SCC 303. Number 2, State of Madhya Pradesh and State of Madhya Pradesh versus Lakshmi Narayan and others reported in 2019 5 SCC, page 688. Number 3, Hussein Ahmed Khan versus State of Nagaland and 2 others within bracket order dated 1/2/2024 in criminal petition number 1, criminal petition number 38/2023. Stop. In Gyan Singh versus State of Punjab and another within bracket Supra, the Supreme Court of India has observed as follows. Quote paragraph number 61 from the judgment. Para 61 from the judgment. Learned counsel for the petitioner has submitted that in view of the compromise reached between the parties, the continuation of criminal proceeding will be an exercise in futility, and the justice in the case demands that the dispute between the parties is put to rest, put to an end, and peace is restored. And therefore, it is submitted that this is a fit case where the FIR lodged by the petitioner number 1 may be quashed. Stop. On the other hand, learned public prosecutor Mr. K.V. Angami has submitted that though he has instructions from the investigating officer of the West PS case number 50/2022 to the effect that the investigation of the said case is under progress. However, it is also submitted by learned public prosecutor that the investigating officer has also submitted that he is in receipt of a copy of memorandum of settlement between the first informant and the accused provided to the investigating officer by the learned counsel for the
It's been submitted by registered by the.
by
Legal advisors,
by
the legal advisor.
by the legal advisor of
By their legal advisor, that
by the legal advisors of the parties. Stop. I have considered the submissions made by learned counsel for both the sides and have perused the materials available on record. On perusal of the judgment of the Apex Court of India in the case of Gyan Singh versus State of Punjab within bracket Supra, it appears that it has been observed by the apex court that where the dispute between the parties are overwhelmingly and predominantly civil in nature, arising out of civil slash comma mercantile comma financial comma commercial comma partnership or like transaction, and the disputes have been amicably settled between the parties, the High Court may be well within the framework of its inherent power to quash the criminal proceeding or criminal complaint or FIR. If it is satisfied that on the face of the such settlement, there is hardly any likelihood of the offender being convicted, and by not quashing the criminal proceeding, the justice shall be casualty and the ends of justice would be defeated. In the instant case also, as the first informant, that is the petitioner number 1, has entered into an amicable settlement and has submitted by learned counsel for the petitioners that all the outstanding dues against the advance payment made by petitioner number 1 to the petitioner number 2 has been settled, it would be futile to proceed with the criminal proceeding, as even if a charge sheet is laid after the investigation, it may not lead to the conviction of the petitioner number 2. And the facts of this case are such that which calls for quashing of the FIR filed by petitioner number 1 for ends of justice. Stop. Next para. In view of above reasonings, this court is of considered opinion that the FIR page number
51 page number.
FIR date, which is the date? FIR filed by the petitioner number 1, on the basis of which West PS case number 50/2022 was registered is liable to be quashed, and therefore same is hereby quashed. And set aside. No, therefore, no. Accordingly, the same is hereby quashed and set aside. This criminal petition is accordingly allowed and
Consequential GR number will be included. The page 59 mentioned on it, the consequential GR case has been.
oh, okay. What is the GR number?
GR number is 2781.
Against the PS case number, wherever PS case number is mentioned, within bracket, mention GR case number 278/2022.
Orders, item number 11.
Lordship, I have taken steps on
The quotation part, quote from Gyan Singh. Here you will get in.
that it is yet to be returned, the notice.
Yes,
read that
item
Lordship.
number,
Item 11 in the orders. Lordship.
Yes,
So I pray that I may be also allowed to, since I've already taken steps by registered ID, I may also be admissible, I may be allowed to take steps by trustee service.
heard Mr. Senti Younger, learned counsel for the petitioner, who submits that he has taken steps for issuance of notice on respondent number 1 and 2 by a registered post with AD. However, the service report is awaited. Learned counsel for the petitioner prays for allowing the petitioner to take fresh steps on the said respondents through Dasti mode also. The prayer is allowed. The petitioner shall take steps as prayed for within 7 days from the date of this
Yes,
order. Within 2 days from the date of this order, returnable after
3 weeks.
3 weeks,
Keep your-
list accordingly.
For orders, item numbers 12 and 13.
Lordship, the service report is still awaited, so kindly let this matter come after 1 week.
Heard Miss Asenla Longkumar, learned counsel for the petitioner, on perusal of the office note dated 22. No, you have not taken fresh steps on respondents.
Lordship, we have taken step through substitute notice, through speak-offs,
When?
16th.
But the office note says that you have not taken steps.
We have initiated through substitute notice.
Substituted notice means through registered post,
No,
through speed post. Then you have to inform the registry that you have taken steps. Though from the office note dated 22 to 2024, it appears that the petitioner's counsel has yet to take fresh steps upon the respondent. However, learned counsel for the petitioner has submitted that the petitioner has taken steps for service of notice on 16th February 2024. Await service report. Let this matter be listed after a week.
For orders, item number 14.
Thank you, the Lordship. Lordship, initially when you filed this revision petition, the complainant is not included. So we filed an IA and accordingly, it was disposed of and we have included the complainant. But there was no order passed for issuing notice to the complainant number 2. And also our prayer for stay has not been heard yet because of not including the complainant.
Now the complainant of what? Which case?
Yeah.
The informant.
Yes, the informant complainant.
Co-
FIR 1.
Now he has been impleted.
Yes, Lordship. And then accordingly, I filed the amended petition. It's been completed as respondent B. Page 3.
Okay. Heard Miss
Upang Nanlalong. Upang Nanlalong.
Opang Nenla Longchar.
It's in the past.
Oh. It is in the cost list.
Yes, the last name. Item number 14.
Yes. heard Ms. Obang Ninla Longcher, learned counsel for the petitioner. Also heard Ms. S. Mere, learned public prosecutor. It is submitted by learned counsel for the petitioner that though initially the petitioner had not impleaded the complainant in this revision petition, however, later on, the petitioner was allowed by virtue of an order passed in interlocutory application to implead the complainant of the FIR, namely Shri Kapmin Thang, as respondent number 2. Stop. Learned counsel for the petitioner has submitted that though the complainant has been impleaded as respondent number 2, no order was passed for issuance of notice on the said complainant, and therefore no steps for issuance of notice could be taken by the petitioner. In view of the submissions made by learned counsel for the petitioner, let the notices be issued to the petitioner number 2, to the respondent number 2 by registered post with ID within 3 days from date of this order, returnable after 3 weeks. The prayer for interim relief shall be considered only after service of notice on the respondent number 2.
For hearing item number 21.
That please also. Am I audible to you also?
Yes. Yes.
So this is quashing of an FIR, my lord. Although, my lord, I'm saying that quashing of an FIR, but the same has not yet been registered as on now, subject to what the, my lord, the learned PP says. It has not been registered, though it was, my lord, complaint was filed way back on 12/9/2022.
What is not registered? FIR was not registered.
FIR is not yet registered. And I came to know pursuant to an, my lord, notice under section 14A, Lordship will find gist of which, my lord, at page 103. May I read?
Just a minute, Mr. Sakya. Yes. Case diary you have not received. But case diary, it has not yet been registered. FIR has. The submission by counsel is that FIR has yet to be registered.
GD entry has been made.
Lordship, I may not take an instruction. Since,
Okay, okay. Mr. Saikya, Mr. Zimomi is praying for 1 week time for seeking necessary instructions from.
Lordship. In that case, my lord, can it be, my lord, in the first week of April, my lord, a little longer date, my lord?
Okay. First week of April. Heard Mr. P.J. Soikya, honored senior counsel assisted by Ms. Tokyek Rulu. Am I right in pronouncing? Learned counsel for the petitioner. Also heard Mr. V. Zimomi, learned public prosecutor, who prays for some time for seeking necessary instructions in this regard.
I'm for respondent number 2.
Also heard Mr. Lima Opang, learned counsel for respondent number 2, who does not have raise any objection to the prayer made by learned public prosecutor. Considering the submissions made by the learned public prosecutor, let this case be listed in the.
It's not 5th of April. No?
Is it okay, Mr. Zimomi?
5th of April is a Friday.
You suggested it.
4th.
4th of April.
Well, in that case, let it be on first of April, Monday it will be.
On the 1st of April.
Right. The interim order passed earlier may continue.
The interim order. What was the interim order?
Well, the interim order was to the effect that if they wish to interrogate the petitioner, that will be done by through video conferencing. I'll not be called to the station, etc.
Okay.
Because in this case, I have already been granted bail, notwithstanding that they had subsequently issued this 41A notices time and again. And the experience was very bad in the sense after the first notice received and the interim bail was granted, after granting the interim bail by this honorable court, I appeared before them in the police station, and what they made to do, they have made me to sign an agreement undertaking all the liability of the present respondent number 2, the complainant.
Okay, let Mr. Zimomi take instructions. Interim order shall continue till next day.
Gotcha.
Not reflected in the cause list. Directed to reflect.
The name of respondent, name of learned counsel for respondent number 2, Mr. Lima Pang, shall be reflected in the cause list henceforth. List accordingly. Cause list.
Yes. घर जाओ
Phone. Phone.
और खत्म हुई